On a train and a bus in a car on the way to your job. All alone with your kids, with your wife or with your dog. You can listen anywhere, you can listen everywhere.
Hello, welcome to the Philip Malowney podcast. I am joined by Dunny Vlogs. This is a special collaboration series where we're going to be looking at the processes from start to finish for the family courts. David Dunn joins me today, and we are collaborating both of our, his expertise and my interest in the family courts and podcasts and video logs, etc. So let me introduce you to David Dunn.
Hello, people. I hope we're all well. My name's David Dunn. I've been what's known as a McKenzie Friend in the family court for some time. 3 years I was in that role for, and it was something that became quite emotive to me, something that was very close to my heart from personal experience, and it was a role that I fell into almost by luck, coincidence. And I must say I'm very, very grateful to be asked to join Philip this evening.
Yeah.
And what a beautiful evening for it is as well, Philip. Don't you agree?
Isn't it lovely? I mean, so geographically, we're in completely different parts of the UK. I'm in south of England, West London area. You are?
I'm currently at my holiday home in North Wales.
Right, still in North
but
Wales.
I'm originally from Liverpool and reside in the Preston area.
Ah, right. Okay, so I didn't know this about you. Blue or red?
Sorry, I'm a blue.
I've got a good friend who's a blue, and I'm not even like 200 miles from Liverpool, but I'm very much a red when it comes to Liverpool. But we can put that aside, David, because we're going to have a very interesting experience here in going through a series of podcasts that are going to take people through the family court. So we need to do a bit of housekeeping around what we're capable of talking about, what you need to understand from what we're saying. We're not legally trained. This isn't strict advice. This is more anecdotal around our experiences. Well, that's what I will be saying. David has obviously got a more in-depth experience through his McKenzie Friend experience. So it's not to be taken as legal advice. If you have any issues, you should seek legal advice, and you should get professional help from either a solicitor or, even McKenzie Friends will probably advise you down that route as well. But anything you'd like to add to that, David?
Yeah, I think it's important to add at that point that anybody can call themselves a lawyer. Nobody can call themselves a solicitor unless they're registered with the SRA, and a barrister has to be registered with the bar. So I don't class myself as a lawyer. I don't like the term McKenzie Friend. I just try and assist people through the court process. And I think it's very important that people have respect for each other's feelings. People have respect that cases are ongoing, because cases in the family court that are ongoing are subject to Section 97 of the Children Act, which means you're not allowed to talk about that case that is ongoing.
Right.
It's further that now, if you breach that, it is a criminal matter and you can be arrested for it. It's further civilly lawed by the 1960 Administration of Justice Act, Section 12, I believe. So it's very important that no names are mentioned and no identity of children specifically are given away. We need to be very mindful about what they're doing. We're here to help.
Yeah.
And we want to try and relay our experiences to you and hope that you benefit from that experience.
Yeah, I think that's a really important point, because obviously, there are people that will see this as, oh, that's really helpful, this is really good, or what have you, or and potentially, any interaction like this could be seen as like are they, they're trying to attack me, or they're trying to put their narrative forward, or what have you. So for me personally, I think, we're going to be going through scenarios and situations, etc. And anecdotally, I might tell you about, what my experiences has been in that. But I'm going to be keeping it to how I feel about it and what my responsibility was in regards to what my actions were. I'm not going to profess to know how somebody else was thinking or how somebody else was feeling. And I think that's probably quite a reasonable way to have my own take on the situation. As we go through this. So those caveats aside, I wonder if it's a good idea to give the folks a flavour as to how we're going to break down these podcasts, this series of podcasts. I mean, first of all, what we're starting with, what we're going to be going on to next, and what they can sort of look to get through this series.
Well, I think today should be a discussion firstly about mediation, the legal requirement for mediation before applying to the family court. This is something I do feel very strongly about. And we can move on from that to the actual application to the family court.
Which is the C100?
Yeah, it's the C100 form. It might be a C100. It could be any of the other forms you need.
Okay.
So we can go on to the C100 and we can do a really good podcast about that. And then,
of course,
how to prepare for the first hearing, whether it's beneficial or not to spend thousands upon lawyers, barristers, McKenzie Friends, whatever. That's again something close to my heart.
Yeah, I suppose, and also, when is it strategically best to spend the money? Because sometimes you just have to spend the money. You might not have the capabilities, etc. But there are often lots and lots of things that you can do for yourself that cut the cost down dramatically.
Well, for example, we've mentioned the C100 form. Now, the last time I checked, it's around £250 to make that application, which I will point out at this point, if you are on any form of benefits, universal credit or ESA or anything like that, it's free to apply. Going on to that form, a solicitor will charge you a further minimum of £250 just to fill out that form.
So just to recap, today we're going to be kicking off with mediation. I'm really looking forward to that. Then we're going to go into the application processes for court as well. Then it will be into things like statements, fact finding, etc. Where the different sort of like avenues that the court might go down. After the application has been put in. And then I think
on that note, Philip, I'm more than happy to provide on our channels templates for statements, because it's not as simple as it seems. So a statement essentially is just what you want to say to the court, and we can't have any input in that. But what we can do is put a template up and you can use that template yourself.
Yeah, and that's helpful for courts as well, because they see something consistent.
The first time I went to court, and this was in my own case, the judge started speaking in Latin, but phrases like Exparte, I thought it was a party with my ex. I didn't have a clue what they were going on about.
Yeah, okay. That's almost like an oxymoron, isn't it?
Yeah. And it's like another phrase, extempore, and there's no need for the law itself to be so complicated when the majority of people who haven't got legal aid and can't afford a solicitor or barrister don't have a clue.
Yeah, we've moved on from the sort of Colosseum, type get-togethers of people, challenging each other's rhetorics, etc. That's a.
No, I think it's interesting you bring that up, because we have moved on from that, but they haven't. Over the years, I've met and become friends with barristers who work in the family court, and they agree that litigants in person should be spoken to as if you're in Costa Coffee or as if you're walking down the street with your dog. But yeah, again, you know, that's something we can bring up on another day. And again, guys, if anyone wants to ask us anything about this, please drop us a comment on either of our channels and we'll answer that. We'll get back to you, and no problem.
That's very important. We do want to hear from you. We do want to hear about, you know, maybe even take us in a direction that you want to, you know, that you want us to go down. You know, once we've done a few of these podcasts, if there's anything that you want to go back into, if there's anything you want to look at a bit more in depth, or if there's something that we haven't covered or that we might have missed and that you'd like to hear about, we can definitely collaborate and do something to hopefully answer some questions. So let's do it. Let's get into mediation. What is it? Why do we do it? Why is it important? And yeah, what are the pitfalls? Because sometimes there's pitfalls.
You know, I became a McKenzie Friend in 2017 after my own case. Somebody asked me to assist them in court. And I'd learned enough around that time to know that mediation is a requirement of the family court. So you have to attend mediation before you can actually apply to the court.
Mm.
Now, there are exceptions to this. So, for example, if domestic abuse is an issue, then you can bypass mediation and go straight to the family court. If one of the parties can't be found, you can apply to the court and just go straight to the court. Mediation itself is, I have to be very careful to be non-partisan here. Mediation is a process whereby yourself and your ex-partner would go and attempt to sort out whatever issue that you're applying to the court for
without going to court.
Yeah. Now, mediation itself is normally done with two people in the same room with a mediator. I represented over 100 people in the family court in the space of 3.5 years.
Mm-hmm.
Not one case was resolved by mediation.
Right.
Not one.
Okay, so what you're saying is in the measurement of 100 people that you have been to, 0 resolved the issues enough to not have to go to family court.
Yes.
So did most of those involve children, or was it
every
financial
single one
assets?
involved? Every single one involved child contact. It's normally a case of one party not allowing the other party to see a child after separation. Mm-hmm. That's normally what happens. And I think it's important to point out at this point that I've been involved in some very serious cases. However, the majority have been parents arguing about an hour or two here and there, or whether overnight stays should be allowed and things like that. Obviously, there are exceptions to that. These are things that could, I believe, be sorted out should mediation work, but not once have I seen mediation work.
So the principles of mediation are to try and get this sorted out without having to use the courts. But the majority of people that find themselves applying for court and then seeing that they have to do mediation as a prerequisite, because you don't just you're not just told that, you know, before you go to court, you are told that, but only when you process. So at the state of mind in somebody's head, you're already divorcing at this point. You're already sort of separating. There's already a bit of friction that's happening within the relationship. So you've kind of set your stall out almost before, like mediation kind of comes in as like an inconvenience to you wanting to achieve your divorce, your child contact arrangements and anything like that. Because correct me if I'm wrong, but in the family courts, you're going to be dealing with all the financials as well as as well as child contact arrangements and things as well?
Not necessarily.
Okay.
Most family law cases involving children are kept separate from financial issues.
Yes. Yes.
So,
But they'd run a parallel, wouldn't they?
yeah, it would still be two separate issues and
Yeah.
quite possibly two separate judges as well. My former clients have made applications for mediation. It's quite frequent that the other party just doesn't attend. Now,
Right.
mediation varies. The mediator can set whatever cost they want. Up here in the north, it's about £150 per session. Probably down south, it's a bit more, like everything else down there.
Yeah.
But I've never seen it work once.
So that's, I mean, that in itself is kind of like so mediation has turned into a tick box exercise. I mean, I don't know. I'd love to hear from a mediator. I'd love to hear from somebody who actually deals with, mediation, and see if they are actually just quite despondent that everything that they are doing to try and help people and mediate and come to an agreement is, by your account, just simply not working.
I think my own opinion on it is that if two people want the best for their child, they can sort it out themselves without asking a third party to become involved. When you're asking a third party to become involved, it's too late. Both parties are already set in stone about what they want.
Yeah.
However, the family court decided some years ago now that there were too many applications coming through. The family court was overwhelmed, CAFCAS were overwhelmed, and they brought in a requirement for mediation. I advised all my clients, and I don't mind admitting this, to avoid mediation.
Right.
I don't believe it helps. I don't believe, mediators do not need a qualification. What happens when you do go and see a mediator is you will be sat in a room with your partner now, or ex-partner as it may be. If your ex-partner doesn't want to sit in that room with you, they will flick from room to room. So you'll be put in separate rooms and the mediator will just convey messages between people.
Yeah.
However, the mediator will ask you about your relationship with the child, and the mediator will ask about safeguarding. It'll be very similar to the first CAFCAS call.
Right.
And, you'll be asked, where do the problems lie?
With mediation, can you see anything as to why mediation might be beneficial outside of it just being a vehicle to alleviate the pressure from the family courts and, like you say, the CAFCAS and social services? Is this just another bolt-on valve, as it were, to the system?
I think the theory behind it is really good. However, I think it comes too late. By the time most people don't know they need to go to mediation first before filling out the C100 and applying to the family court for contact or overnight stays or a variation of a current order. They only realise that. People only realise that when they pick up that C100 form. And it says quite clearly on the C100, it is a legal requirement for you to attend mediation. And you have to get that form signed off by a mediator before you can actually apply to the family court.
Right.
I can only go on my own experiences in the family court. Out of over 100 cases, not once have I heard of anybody who achieved an agreement by mediation. It's important for us to be neutral. Maybe we could invite a mediator on sometime and have a chat with us, but they will have a different view and say, oh, well, we have thousands of families. And so I don't think that, do you see where I'm coming from? No,
absolutely. Did you ever go to
role?
Were you ever involved in mediation through your own personal experience? Obviously, I don't need to have details, but did you go through that actual process of mediation?
No, I didn't go through mediation.
Okay.
There is a way from personal experience.
Mm.
There is always a way to avoid mediation. They give you enough reasons for it. Now,
Yeah, absolutely.
What did happen, and this was a case in, I think it was Wigan Family Court, and obviously I can't name the parties, but
Sure.
father had applied for contact with a young child under 10. No mediation was applied for. He bypassed it for some reason. I think it was mental health or one of those, something along those lines.
Mm-hmm.
So we ended up going to court. I ended up being the mediator. So
Right.
it's always in the courts and the children's best interest for parents to agree.
Yeah.
I don't believe that any case should go to the wire or the final hearing, if we like. It's always best for parents to turn around, bite the bullet and say, look, okay, no worries. And my client in this case and her ex-partner were pretty close to agreement. So we went to court that day. He'd previously hired Queen's Counsel barristers who are expensive, looking at probably about £750, £850 an hour.
Yeah.
But on this occasion, he turned up at court on his own. So I went and sat down with him and said, look, my client wants you to see your son. You want to see your son. However, because of the evidence before us, we have to have certain rules in place.
Right.
Now, we can go in there and argue, and we can argue for the next 6 months if you want. But if you say yes today, it starts the ball rolling. And that, as a McKenzie friend, was something important to me because I never put my client first. I always put the child first. I made sure my clients knew that.
Yeah, I mean that's a great way to be. I mean, I said earlier as well that I'd been through mediation. I haven't been through. I was assessed for mediation, and I thought it was going to be fine. I thought it was going to be absolutely fine, but then I was told that I was completely unsuitable for mediation, and hopefully, and I don't take it personally, they felt that I hadn't let go of what was happening to me, with my, obviously whatever was happening. That was their opinion. So if I could impart any knowledge from my experience, it would be a case of you've got to truly have let go of, what happened to you and focus in on the children. So you're right when you say, when you speak to your clients, the first thing you say is I'm sort of here for, if you say something along the lines of, I'm here for the child and their best interests, and you're a vehicle for that to happen, because obviously you're their parent. You're going to be the person who, once I walk away, you're going to be the person they're left to do the job, and you might consider that if there's somebody else there who is willing to help you do that job, that that's not a bad thing, given any other caveats to whatever's going on in that relationship, because we are talking about a minefield. But back to the mediation, it was deemed that I wasn't ready for mediation, which was in a way quite strange, because the prerequisite to sort of family court was mediation. But they never let me mediate. And like, I took it quite literally. Oh, this is mediation. So, the questions were, what's the issue? What's going on, or what have you? And I said, look, this is the issue. That's the issue. And their interpretation of me telling them what the issue was I hadn't let go of it. So I don't know if they wanted me to say, oh, I'm fine, there's no problem anymore, or something along those lines. But I just found it so counterproductive, or just, I felt like they were happy to sort of call it a day on the basis that they thought that, I wasn't ready to
That's a really interesting point that you bring up, because if mediation is a prerequisite or requirement for the application, and you get refused it, where do you go then?
Well, that's right. It's like so I still have the same, I still have the same story. I still have the same narrative, um, going into court. Um, so it was a weird one for me. It was like I could almost not believe it. And one of the difficult things of being a man in the family courts is you can just get labeled like that. Boom. Like someone could look at me, and if there was a story about me being at all violent or at all aggressive, it's very believable. It's very, very believable. I guess what I'm trying to sort of squeak out of this is that perception is everything. Perception is everything when you're going through this, because you might not want to go through it. Okay, so it might not be something that you want to do, but you might be getting dragged down this course of family court in order to do something like have contact with your children. It's a very real scenario that might be
Yeah,
happening for you. So what I'm trying to say is perception is everything. So whether you feel really hard done by, whether you feel that this is a complete injustice, you've got to be uber careful as to how you come across and what you're talking about and how
exactly.
you're saying it. So that's my number one takeaway point from it.
Yeah, yeah,
So you've got to kind of like, you've got to drop the ego, you've got to drop all the stuff
yeah,
that you feel that somebody might go, oh, that's terrible that that's happened to you, because actually they don't
yeah,
want to hear it. That's my sort of 2 cents worth on the matter of mediation. If I can impart that onto anybody, and if that helps, then great. But is there anything else that you'd like to add, David, in wrapping up this first segment of ours?
yeah. I think it's important, and remember, this is just opinion. I think it's important to go through all the reasons not to go to mediation rather than rush into it. When we get onto the C100 form, there are 2 pages of lists why you don't need to go to mediation. My own opinion is that it's a worthless and expensive process that I have never once seen work. I don't believe for one second that it hasn't worked or it doesn't work. I have never seen it work. It's money that you don't need to spend. And most importantly, you apply for mediation, your court case gets put back a month. So you
Yeah.
ring up the mediator then has to write to the other party, whether that be mum or dad. Then they have to wait 2 weeks.
Yeah.
Then they have to make another call. 6 weeks, your case is going behind without contact. And I've
Yeah.
never once seen it work. So go through the C100. There might even be 3 pages on the C100 of reasons why you don't need to go to mediation.
Right.
I don't believe it works. That's just my opinion. Next time, I think we should go through the process of the C100 form. What do you think?
Yeah, absolutely. It's an application that you can get a lot of information down on, and we'll go through, how useful or unuseful that can be in the first part of in the first, well, I suppose the first step on the road down the family courts. So I'll be really looking with interest as to what you've got to say about that next time.
Brilliant. And then after that, guys, what we're going to try and do is move on to how to prepare for the first hearing. And I'd also like to touch a little bit on mental health as well, because I think it's very important to do the right things, make sure we're all emotionally balanced. Myself and Philip both know how difficult this is. I'm sure we've both been in very dark places.
Yeah.
And I'm sure we're both living proof that you do come out of the other side. So
Yeah. Well, so just a very brief plug. Actually, I've got an old friend of mine who I've just spoken to today. His name's Dave, and he's going to be talking to me exactly around that. He's very good at yoga. He's very good at
right,
yoga, and he's very good at sort of making sure that he takes care of himself and what have you, so that he can be in the right mind frame, etc. Going through, and he has pieced together his benefits and how that can probably help people, but definitely help people who are going through these sorts of traumas, really.
Yeah, and I think that's very important. And maybe we can get Dave on one time to have a very quick chat and talk to guys. You know, if it's you see, the problem with mental health, whether you be male or female, it's something you don't like to talk about. So I think it would actually be brilliant to have Dave on a vlog one time and see what we can do.
Yeah, no,
Brilliant.
definitely. Right, well, thanks everybody. Yeah, thanks everybody for tuning in. You know, you're going to be able to interact with myself, and make sure that you subscribe and you like and you share this video to anybody that you think could benefit from it in regards to the family court. And it's going to be Dunny's vlog and the Philip Malowney podcast. It's been a very nice collaboration, and here's to the next one, Dave.
Brilliant. Thanks very much indeed, Phil. You have a good evening.
All the best. Take care, pal.
In a car on the way to your job. All alone with your kids, with your wife, or with your dog. You can listen anywhere. You can listen everywhere. To the Philip Malowney podcast.